All right, so welcome all of you. Welcome to Siddhartha IAS. So we are discussing fundamental rights, and so far we have discussed till Article 14, right? Right to equality before law and equal protection of law, right? So in this class we are going to discuss the next and one of the most important articles in the Indian Constitution, that is Article 15, right? Article 15. So I've told you that Articles 14 to 18 provide for right to equality. And one of the foundational value of equality is absence of privileges and absence of discrimination, right? What is equality? Sorry. What is equality? Equality means absence of privileges or absence of discrimination. Discrimination means unjust treatment of any particular individual, right? So this Article 15 deals with prohibition of discrimination, right? That is the subject matter. So in detail, Article 15 has 6 clauses. There are 6 clauses in Article 15. We will discuss each clause one by one. So what is the title of Article 15? Title of Article 15 is Prohibition of Discrimination on Grounds of Religion, Race, Caste, Sex, or Place of Birth, or any of them. This is the basic title of it. I'll discuss it in detail, right? So what is Article 15 Clause 1? Article 15 Clause 1 states that the state, mind you the word, the state, S capital, shall not, the state shall not, what? Discriminate. Against whom? Against any citizen, any citizens, on grounds, focus on keywords, on grounds, only of, mind you, these are the keywords, the state, citizens, only of religion, race, caste, sex, place of birth, or any of them. This is exactly what is provided under Article 15 Clause 1, right? The state shall not discriminate against any citizens on grounds only of religion, race, caste, sex, place of birth, or any of them. Now there are 3 important things to be remembered in this article. Number 1, the right, the fundamental right under Article 15, under entire Article 15, including Clause 1, it is available only to the citizens. It is not available to the foreigners, right? When it comes to Article 14, Article 14 uses the word persons. No person, right? Or state shall not deny any person equality before law or equal protection of law. So the word used in Article 14 is person. So that's why Article 14 is available to citizens as well as foreigners. Whereas fundamental rights under Article 15, it is exclusively available only to the citizens. It is not available to non-citizens, that is foreigners. Number 1, okay? This is the key word. Second, the state, who shall not discriminate against the citizens? Who? The state. So I told you while discussing about the features of fundamental right, I told you that there are certain fundamental rights, or I mean all the fundamental rights are available against the state, but there are certain fundamental rights which are available against private individuals as well, right? What about this fundamental right under Article 15 Clause 1? The Article 15 Clause 1 talks about the state. It mentions the word the state. It means that it is available, this fundamental right is available only against the state. It is not available against private individuals. So it means that private individuals can discriminate on grounds only of religion, race, so on and so forth. I, as a private individual, might not allow a person belonging to a particular caste, person belonging to a particular religion in my house. And that is a discrimination only on the grounds of religion or caste. Right? And that is not violation of fundamental right under Article 15 Clause 1. Why? Because this fundamental right under 15 Clause 1, it is available only against the state. State cannot discriminate against citizens on grounds only of this. But the private citizens can discriminate. Ideally, they should not, but considering the scope of Article 15 Clause 1, it is available only against the state. Clear? Second thing. Third, and the most important, the most important keyword in Article 15 is only. Now, what is meaning of the word only? So the meaning of the word, see, there can be various grounds of discrimination. There can be various grounds of discrimination. The word only means state cannot discriminate against the citizens only, solely, exclusively on any of these grounds. Meaning state cannot discriminate against any citizen only on the ground, only on caste ground or caste basis, only on the basis of religion, or only on the basis of sex or gender, or only on the basis of race. No. Right? So the word only means these 5 grounds: religion, race, caste, sex, or place of birth, or any of them cannot be the sole, cannot be the only ground of discrimination. So if government frames any law, or if government frames any policy, right, according to Article 15, okay, it should this policy should not provide any discrimination only on any of this ground. But there can be other grounds of discrimination. So it means that citizens can be discriminated on the basis of additional grounds, but not solely on these grounds. Got it? Let me give you an example. Now, in Indian Army, right, women are not allowed to enter into certain combat positions, right? Now this is, if you can argue that this is a discrimination solely on the basis of sex. But it is not so. There is another basis of excluding women from combat roles, and that is biological basis. Okay, right? So if you study biology, you know there are 2 hormones you will study about, right? Estrogen and testosterone, right? So due to the secretion of estrogen, the women body, they have more fat, and then you know they physically they are I mean due to the estrogens, they as compared to men, due to the secretion of testosterone, the men are more physically fit for you know difficult jobs like combat operations, right? So here exclusion of women from certain combat roles is not solely on ground of sex. There is additional ground as well. Along with the gender, there is additional ground, that is physical fitness. Right? Okay? Then there can be other grounds as well, like intellectual and physical fitness can be additional grounds on which citizens can be discriminated along with all these grounds. So the point ये है कि सिर्फ ये 5 grounds पे discrimination नहीं हो सकता है. But if there are additional or other grounds on which the discrimination exists, then that is allowed. आप solely exclusively only इनके हिसाब से आप discriminate नहीं कर सकते. Another example, ठीक है? Now the various nursing schools, they prefer female candidates in gynecology course. Right? Now this is not the discrimination only on the grounds of sex, it is also on cultural grounds. On cultural, because women culturally they prefer this gynecology profession or the nursing profession, right? So that's why they are given preference vis-a-vis men. Got it? समझ में आया? Only का मतलब है. So it means that state can discriminate against citizens but it cannot discriminate against citizens only solely on any of these grounds. Okay? But state can prescribe physical or intellectual fitness as one of the grounds. Okay? For entry into any particular profession or entry into any particular job, right? समझ में आया? हाँ, ठीक है, right? अब आप ये नहीं कह सकते कि suppose there is a cutoff for a university, right? Now there is a particular cutoff. What is that cutoff? Cutoff is a criteria related to intellectual fitness. You have that you should fulfill that particular criteria, then only you can enter, right? लेकिन अगर कोई particular educational institutions they are denying admission to the candidate despite of fulfilling the cutoff only on the basis of caste or gender or religion or race, then that is violation of fundamental right provided under Article 15 Clause 1. But cutoff is additional ground, right? Then that is allowed. समझ में आया? क्लियर है? तीन चीजें हैं आर्टिकल 15 क्लॉज. दैट इज व्हाई इट इज वेरी इंपॉर्टेंट टू रीड द कॉन्स्टिट्यूशन वेरी केयरफुली. Each and every word used in the constitution, it has its own meaning and significance. Look at Article 15 Clause 1. Three things: the state available only against the state, not against the private individuals. Okay? Then citizens available only to the citizens, not to the foreigners. Only means there cannot be, these five cannot be the sole grounds, only grounds of discrimination. There can be additional discrimination as well along with all these factors. Got it? Clear? बहुत बढ़िया. Now next, Article 15 Clause 2. Now Article 15 Clause 2 is basically related to the historical practice of untouchability in India, right? Right from the ancient times, even today, practically speaking, the Dalits, right? Dalits or certain sections of society, they are not allowed to enter into certain public spaces. Right? Okay? For example, Dalits were not allowed to use public roads. They were not allowed to drink water out of public well or tanks. They were not allowed to enter into hotels, so on and so forth. Right? So on the basis of untouchability. Right? So Article 15 Clause 2 is related to that particular practice. Right? So Article 15 Clause 2 states that no citizen shall on grounds only of. Achha, I forgot to tell you one thing. The Article 15 Clause 1 does not prescribe language as a criteria. So citizens can be discriminated on the basis of language. ठीक है? तो इसीलिए आप स्टेट PSC देखते हो कि फॉर एग्जाम्पल आई एम फ्रॉम महाराष्ट्र. सो महाराष्ट्र, इफ यू वांट टू क्लियर Maharashtra State Civil Services, you should know Marathi as a language, right? So you cannot say that this is violation of, and this is discrimination on the basis of language. But does the Article 15 Clause 1 mentions language? No. So that is why that is not violation of your fundamental right under Article 15 Clause 1. Got it? Okay. No citizen shall on grounds only of what? Only of religion, race, caste, sex, place of birth, meaning domicile, or any of them, no citizen shall on grounds any of them be subject to any disability, liability, condition, disability, liability, restriction, condition or condition with regard to what? With regard to what? With regard to, so Article 15 Clause 2 is very specific. With regard to subclause A. Okay? With regard to access to what? Shops, shops, public restaurants, hotels, and places of public entertainment. So places of public entertainment also include cinema halls. Okay? So no citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, shall be subject to any disability, liability, restriction, or condition with regard to following. Number 1, A, access to shops, public restaurants, okay, hotels, and places of public entertainment. Okay? B, use of wells, kuwa, tanks, bathing ghats, roads, and places of other places of public resort maintained, now this is very important, maintained wholly or partially out of the state funds, or dedicated to the use by general public, dedicated to the use by the general public. ठीक है? This is exactly what and I'm writing because it is very important. ठीक है? Second क्या है? Use of wells, tanks, bathing ghats, roads, and places of public resort maintain wholly or partially out of the state funds or dedicated to the use of general public. So suppose you have a house, you have a private house, and within that house you have constructed the road, and if you do not allow Dalits to use that road, will that be a violation of fundamental right under Article 15 Clause 2? No. Why? Because it is not wholly or partially out of the state funds. That's my private property. That's my private road. I will do whatever I want to do. Right? So Article 15 Clause 2 is about access to public places, those which are available to public. So if the places, if public parks, for example, if public parks are available to all, then they should be available to all. There should not be any prohibition for, say, Muslims or, say, any particular women, gender, or men, right, to enter into that public parks, because they are public property. Right? Okay? So remember this wholly dedicated. So whatever public places are there which are maintained by the state or wholly or partially, ठीक है, funded by the state, वहां पे आप किसी की एंट्री डिनाई नहीं कर सकते ऑन ग्राउंड्स ओनली ऑफ रिलीजन, रेस, कास्ट, सेक्स, प्लेस ऑफ बर्थ और एनी ऑफ देम. समझे इसका कॉन्टेक्स्ट. अब और एक इंपॉर्टेंट चीज, ठीक है, इफ यू रीड आर्टिकल 15 इट यूजेस द वर्ड नो सिटीजन. राइट? सो फंडामेंटल राइट under Article 15 Clause 2, it is not only available against the state, it is also available against private individuals. Okay? It is also available against private individuals. So the scope of Article 15 Clause 2, it is broader as compared to Article 15 Clause 1. Article 15 Clause 1 is available only to the citizens, only against the state, right? Only against the state, whereas this is available not only against the state. So not only the state should deny entry into the public places to all to all the people, but also the private individuals. Okay? Now again, what is the meaning of only, right? Okay. Suppose I am a restaurant owner. Okay, I am a restaurant owner, and restaurant is a public place. Is it a public place? Even if it is a private property, but it is a public place. It is open to all. So I, as a owner of restaurant or hotel or shop, I cannot deny entry. I cannot, or cinema halls, I cannot deny entry to certain people only on the grounds of religion, race, caste, sex, or place of birth. I cannot say that this particular cinema hall or public restaurant is open only to Hindus. It is not open for Muslims. Can I do that? No. Why? Because Article 15 Clause 2 is available not only against the state but also against the private individuals. Clear? Right. But there can be certain additional grounds as well. For example, I, as an owner of public restaurant can say that if a person is not properly dressed, if person is not properly attired, then I might not allow that person. Right? But is this discrimination is only on any of these grounds, or religion, race, so on and so forth? Nahi. There is additional ground as well. It can be an additional ground. Right? The religion discrimination and all this can be additional grounds, but not the only grounds. ठीक है? Right? So इसलिए आपने देखा होगा बहुत सारे रेस्टोरेंट में जो है जैसे beggars are not allowed, or if you are not properly dressed, they will not allow you. Yes, she was wearing sari and all. Okay, right? Okay, so that is absolutely okay. That was not violation of fundamental right. है कि नहीं? That is not a violation of why she was prohibited entry. Not because she was lady or she was female, but because of her dress. So a restaurant might prescribe a particular dress code. ठीक है, right? For entry. ठीक है, समझ में आया? Right? बट अब उनको क्या किया, वो उस रेस्टोरेंट को बंद किया गया, उस जो भी है, किसके ऊपर? इसके ऊपर नहीं, अकॉर्डिंग टू आर्टिकल 15 क्लॉज 2 नहीं, कुछ अलग कि आपने म्यूनिसिपैलिटी के जो है वो सर्टिफिकेट नहीं है आपके पास, XYZ नहीं है ना, हाँ, जो बहुत सारे रूल्स होते हैं, हाँ, राइट, उसके वजह से उनको बंद कर दिया. बट नॉट ऑन द बेसिस ऑफ दिस, द रेस्टोरेंट ओनर वाज वेल विद इन हिज और हर राइट टू प्रिस्क्राइब अ पर्टिकुलर ड्रेस कोड. समझ में आया? Right? That is why it is very important to understand the constitution. That is what makes us different than the common people, because we are a student of constitution. All right. Second, I as a owner of, say, cinema hall or public restaurant or hotel, I can also prohibit the people who are, say, carrying communicable disease like COVID. So I might prohibit them to enter into my hotel or into my shop, right? So this is allowed. This is not a discrimination. This is not a violation of a fundamental right under Article 15 Clause 2. Got it? Clear है? ठीक है? Good to go. Next. And public places कौन से होने चाहिए? Either wholly or partially maintained out of state funds or dedicated to the use by general public or of general public. ठीक है, तो जो भी जनरल पब्लिक प्लेसेस है, ठीक है, नाउ यू एज एन इंडिविजुअल माइट बी टेकिंग दिस फॉर ग्रांटेड, ओ इसमें क्या है, बट द हिस्ट्री, इफ यू लुक एट द हिस्ट्री ऑफ इंडिया, देयर हैज बीन डिस्क्रिमिनेशन और सिस्टमैटिक एक्सक्लूजन ऑफ सर्टन सेक्शंस ऑफ सोसाइटी फ्रॉम वेरियस public sphere, from this public sphere. They were confined only to the private sphere. For example, women were denied right to education. Right? They were denied right to education. Then Dalits were also denied right to education. Right? Education or educational institutions, they are public places. Dalits were denied entry into various religious institutions. Right? Okay? Right? Now that is a different thing. If you deny entry to particular women in the temple, right? So the temple is a religious institution. It is not a public. Even though it is a public place, but it is a religious institution. And even the Supreme Court of India has in multiple cases, including Sabrimala case, has said that you cannot deny the entry of, say, women or Dalits into temples. But that is not within the scope of this particular. That is a different issue. Right to freedom of religion. And yes, I mean, you can say that this is also, yes, you can say that denying entry of women into temples is also discrimination solely on sex, solely on grounds of gender. So you can say that this is also violation of Article 15. It's a discrimination solely on the gender. But they say that no, this is not a discrimination solely on a ground of this. There is a biological reason as well, menstruation, so on and so forth, right? So the entire debate go on, and ultimately Supreme Court said that this is unconstitutional, and women are now been allowed to enter into Sabrimala, right? And this same was the case in case of Haji Ali Dargah, right? So even in this case, court said that it is violation of fundamental right. Anyways, Article 15, Clause 3. Now, Article 15, Clause 3, Clause 4, and Clause 3, 4, 5, 6, okay? They are exception to Article 15, Clause 1 and 15, Clause 2. Okay, what is Article 15, Clause 3? Nothing in this article, आर्टिकल का ए स्मॉल होना चाहिए. हाँ, मैं हमेशा कैपिटल लिखता हूँ. नथिंग इन दिस आर्टिकल, विच आर्टिकल? 15, राइट? नथिंग इन दिस आर्टिकल shall prevent whom? The state, prevent the state, S should be again capital, prevent the state from making any special provisions to women and children. Nothing in this article shall prevent the state from making any special provision, it should be singular, it should be making any special provision to whom? To women and children, right? So it means that Article 15, Clause 3 empowers the state to make certain special provision to women and children. Why? Now in the last class I've told you about difference between equal protection, equality before law and equal protection of laws. And at that time I told you that the equality before law is, it has negative connotation. Okay, right? And it means absence of privileges and equal subjection of all the citizens to the ordinary laws administered by ordinary law courts, and no one is over and above the law. That is what equality before law means. Okay? But equal protection of law, I told you that equal protection of law is positive. It is a positive concept. So equal protection of law means, in simple words, treating equals equally and unequals unequally. Right? So equal protection of laws provides foundation of affirmative action and distributive justice. Right? Okay? So that is what Article 15, Clause 3 tries to do. You know, right? That, you know, now what at that time I told you that equality before equal protection of law means treating equals equally and unequals unequally, meaning equality of treatment under equal circumstances, equality of treatment under equal situations. But in India, can you say that men, women, children, they are under equal circumstances? No, they are not under equal circumstances. Their life chances are not similar. There is patriarchy in Indian society. Women are discriminated, right? They are still excluded from public sphere. There is a systematic discrimination, right? So women and men are not similarly placed as far as India is concerned, and across the world as well. So that is why state should be permitted to make certain special provisions to women. Same is the case with children, right? Children need support of the state, right? So that is what is the scope of Article 15, Clause 3. Now special provisions. Now if you make special provisions to women, it means that in a way it is a discrimination only on ground of sex, right? So Article 15, Clause 3 is exception to discrimination on solely on grounds of sex, right? For example, women are given fee concession in UPSC. In UPSC, women can fill the form free of cost. They don't 100 rupees fee है ना, right? कितना है? विमेन के लिए मेन के लिए कितना 100 रुपीज फी, लेकिन क्या विमेन को फीस लगती है? नहीं लगती है. सो इज इट द डिस्क्रिमिनेशन ओनली ऑन द ग्राउंड्स ऑफ जेंडर? यस, इट इज अ डिस्क्रिमिनेशन. Yes, it is a discrimination. Only women are excluded from this condition of paying fees, not men. So this is the discrimination solely on the basis of gender, but it is allowed under Article 15 Clause 3. That is why Article 15 Clause 3 states that nothing in this article shall prevent the state. Got it, right? Then there is fee concession, there are scholarships. So what UPSC says that, we want to encourage women into civil services. There are no enough women in civil services. To encourage women to enter, more and more women to enter into civil services, UPSC exempts women from fee payment. That is the logic. Okay? Then the CRPC, the Code of Criminal Procedure of India, it also, there are certain sections, I think it is section 437. Okay? Under this section, it is easier, the conditions to get bail to a woman, they are lenient as compared to men. So it is easier for a woman to get bail as compared to men. Now this is a special, it's a special provision. Is it allowed or not? Yes, it is allowed. Under what? Under Article 15 Clause 3. Okay, right? Fine. Then there are other examples as well, but I hope you have understood this. Okay? State is allowed to make special provisions to. अच्छा, और एक, अब जैसे हम लोग फ्लाइट में ट्रैवल करते हैं या ट्रेन में ट्रैवल करते हैं, तो सर्टन एज तक बच्चों के लिए कोई टिकट नहीं होता है, ठीक है, फ्री है. या हम पार्क में जाते हैं या कहीं सिनेमा हॉल्स में जाते हैं, उनका टिकट प्राइस कम होता है. स्पेशल प्रोविजन टू द चिल्ड्रन, राइट? गॉट इट? आर्टिकल 15 क्लॉज 3. Right? So Article 15 Clause 3 and other articles, okay, they basically are positive. Their purpose is to ensure equal protection of laws. Okay, let me tell you to simplify this. Okay, there are 6 clauses in Article 15. Clause 1, Clause 2, Clause 3, Clause 4, Clause 5 and Clause 6. Okay, Clause 1 and Clause 2 of Article 15 speaks the language of equality before law, whereas clauses 3 to 6 they speak the language of equal protection of laws. This is the difference between clause 1 and 2 and other clauses of Article 15. Okay? So clause 3, 4, 5 and 6, they are enabling in nature. They enable the state to make special provision to certain sections of society who are disadvantaged, who are marginalized, who are excluded, so on and so forth. Got it? Clear? Fine. Now, original Indian Constitution, it had only under original Indian Constitution, Article 15 had only 3 clauses. Clause 1, Clause 2, Clause 3, and we have discussed that. Okay? And Clause 4, 5 and 6, they were added to the Article 15 later on. Okay? So what is Article 15 Clause 4? Okay? Nothing in this article, or, now this is very important, this is very interesting, most of the students, they miss this point. Okay? Nothing in this article or in Clause 2 of Article 29. Nothing in this article or in Clause 2 of Article 29, right? Article 29 Clause 2, okay? Shall prevent the state from making any special provision. यहाँ तक तो सेम है, except Article Clause 2 29, ठीक है? Special provision for the advancement of the socially and educationally backward classes of citizens. Again, the word citizens. or for the scheduled castes and scheduled tribes. For scheduled castes and scheduled tribes. Article 15, clause 4. Nothing in this article or in clause 2 of article 29 shall prevent the state from making any special provision for the advancement of socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. Mind you, article 15 clause 4 does not mentions economically backward. It does not mentions. It says that the special provision can be provided to socially and educationally backward, not economically backward, socially and educationally backward classes of citizens and for the scheduled caste and scheduled tribes. Okay, right? Now this article 15 clause 4, it was added through first Constitutional Amendment Act. First Constitutional Amendment Act 1951. It was not there under original Indian Constitution. Okay? Article 15 clause 4 was inserted through first Constitutional Amendment Act 1951. Mind you, the first Constitutional Amendment Act was passed by the provisional parliament. Okay? Because the general elections to the first Lok Sabha, they were conducted in 1951-52, right? And the first Lok Sabha was constituted in 1952, right? And I told you that the Constituent Assembly also performed the dual role. One was of framing the constitution, another was of provisional parliament. Okay? So once the constitution was made or framed, the Constituent Assembly was not dissolved. I mean, Constituent Assembly already completed its task of making the constitution, but it continued. The members of Constituent Assembly, they continued their work as legislators. Okay? Now, why the first Constitutional Amendment Act was passed and why Article 15 clause 4 was inserted? I already told you while discussing basic structure doctrine, I discussed about the first Constitutional Amendment Act. Okay? Right? And the constitutional validity of first Constitutional Amendment Act was challenged in Shankari Prasad case. Got it? Remember? Okay? Now, the first Constitutional Amendment Act dealt with so many issues. ऐसा नहीं है कि एक Constitutional Amendment Act सिर्फ एक ही issue को deal करता है. वो एक ही issue को भी deal कर सकता है या उसमें multiple चीजें भी हो सकती हैं. ठीक है? Right? For example, first Constitutional Amendment Act also, along with other things, it's also added Article 31A and Article 31B and 9th schedule. Right? And it also added Article 15 clause 4. It also amended Article 19. Right? Okay? So a Constitutional Amendment Act can deal with so many things, like 42nd Constitutional Amendment Act, which is called as mini constitution. It made changes into various provisions. Okay? So don't get confused. Okay? Now what happened? There was one case. Okay? The state of Madras, this first Constitutional Amendment Act 1951 was passed to nullify the Supreme Court judgment in the state of Madras, versus Champakam Dorai Rajan case. 1951. Why first Constitutional Amendment Act was passed? Along with other reasons, one of the main, or why Article 15 clause 4 was inserted? It was inserted to nullify the Supreme Court judgment in the state of Madras versus Champakam Dorai Rajan case 1951. In this case, the Madras government's order of reserving certain seats to certain castes or socially and educationally backward caste, it was challenged. Madras government, it came out with the order that the certain seats in certain educational institutions, or engineering or medical colleges, will be reserved for certain sections of society. Right? Okay? Now, this particular Madras government order was challenged. In this case, in the Supreme Court, in this case, petitioners, they argued that the petitioners they argued that this is violation of my fundamental right guaranteed under Article 15, because Article 15 prohibits discrimination on grounds only of caste. Okay? Then the candidate also argued that this is violation of right to equality under Article 14, under Article 15, it is violation of Article 29 Clause 2 as well. Now what is Article 29 Clause 2? What is Article 29? Article 29 is about protection of interest of minorities. So Article 29 Clause 1 states that any section of citizens residing in the territory of India or any part thereof having its own language, culture or script shall have right to conserve the same. That is what Article 29 Clause 1 is all about. Okay? Now what is Article 29 Clause 2? Article 29 Clause 2 states that no citizen shall be denied admission into educational institutions maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste, language or any of them. Okay? Let me write Article 29 for you for clarity. Article 29 Clause 2. ठीक है? क्या है? No citizen shall be denied admission in public funded education institutions. ठीक है? Admission in educational institutions, in any educational institution. ठीक है? Maintained by the state or receiving aid or receiving aid out of the state funds on grounds only of, the grounds are different, only of religion, race, caste, language or any of them. This is really interesting. No citizen shall be denied admission to any public funded education institutions on grounds only of religion, race, caste, language or any of them. What are the grounds missing which are mentioned in Article 15? Sex or ठीक है, religion, race, caste, sex, place of birth. ठीक है, place of birth is missing. ठीक है, and the language has been added. Gender is also missing. ठीक है, इसीलिए कुछ कॉलेजेस जो है उसमें एक लोकल कोटा होता है. ठीक है, कि हम जो है जैसे महाराष्ट्र के कुछ कॉलेजेस सपोज है वो कहेंगे कि महाराष्ट्रियन के लिए दोज हु आर डोमिसाइल्ड इन महाराष्ट्र, ठीक है, द सर्टन सीट्स विल बी रिजर्व फॉर देम. ठीक है, बट इट इज नॉट प्रोवाइडेड अंडर दिस. ठीक है, राइट. अच्छा, जेंडर इज मिसिंग. ठीक है, जेंडर इज मिसिंग. सो दैट इज व्हाई, दैट इज द रैशनल बिहाइंड गर्ल्स कॉलेज. हाँ, राइट. फॉर एग्जाम्पल आई टीच इन गर्ल्स कॉलेज, राइट. हाँ, तो वहां पे क्या है, यू कैन नॉट से दैट मेल आर बीइंग डिनाइड एडमिशन इनटू दिस पर्टिकुलर इंस्टीट्यूशन. व्हाई? ठीक है, बिकॉज जेंडर इज नॉट मेंशन्ड हियर. ठीक है, सिटीजन कैन बी डिनाइड एडमिशन ऑन द बेसिस ऑफ जेंडर, सेक्स. ठीक है, एंड दे कैन ऑल्सो डिनाइड एडमिशन ऑन द बेसिस ऑफ प्लेस ऑफ बर्थ, डोमिसाइल. समझे? ठीक है. अब क्या है, मद्रास गवर्नमेंट ऑर्डर क्या था कि इट दिस ऑर्डर वाज रिजर्विंग सर्टन सीट्स in government educational institutions, engineering and medical colleges for certain castes. ठीक है, राइट. ठीक है, उसमें कुछ पर्टिकुलर रिजर्वेशन था. ठीक है, अब सुप्रीम कोर्ट में ये चैलेंज किया गया. क्या चैलेंज किया? बोले इट इज वायलेशन ऑफ फंडामेंटल राइट अंडर आर्टिकल 14, अंडर आर्टिकल 15, इट इज प्रोहिबिशन ऑफ डिस्क्रिमिनेशन ऑन ग्राउंड्स ओनली ऑफ कास्ट. There are certain seats reserved for minorities as well on the basis of religion. तो बोले how can you have religion, how can you discriminate on grounds only of religion or caste? So violation of article 14, 15, also under article 29 clause 2. Supreme Court of India upheld this particular argument, and it held Madras order as unconstitutional and null and void. And this was a very serious setback to the government. It means that government cannot make reservation to the Dalits or other educationally and socially backward classes of citizens. And why? Supreme Court said that. Now the government argued that the Madras government, they argued, the state of Madras, it argued that we have issued this order under Article 46, which is in Directive Principles of State Policy. Article 46 states that, you know, state shall promote with special care educational and economic interest of weaker sections of the people, and in particular scheduled caste and scheduled tribes, and protect them from social injustice and all forms of discrimination. So government ने क्या कहा कि भाई we have issued this government order to implement the directive principle of state policy enshrined in Article 46. They said that, look at what is Article 37 says, that yes, directive principles of state policy, they are not justiciable, but it shall be the duty of the state to apply these directive principles in making laws and policies. That is what we are doing. Okay? So the question was relationship between fundamental rights and directive principles of state policy. Can you, to implement directive principles of state policy, can violate the fundamental rights? Which has more priority over the other? The Supreme Court in state of Madras, versus Champakam Dorajan, said that fundamental rights, they should have primacy over the directive principles of state policy. So in implementing any of the directive principles of state policy, you cannot violate the fundamental rights. But at the same time, Supreme Court said that fundamental rights can be amended by the parliament under Article 368. So this was a serious setback. So that is why central government, it decided to amend the constitution, and that is why it is exclusively mentioned through Article 15 clause 4 that nothing in this article and in Article 29 clause 2, because the challenge was on Article 29 2 as well. Okay, nothing in this article or under Article 29 clause 2, nothing in this article shall prevent the state from making special provisions to socially and educationally backward classes of citizens and scheduled castes and scheduled tribes. Okay? It's general. It's very. But where such a special provision, or that what would be the scope of that special provision, or what is the content where the special provisions have been provided? It is not mentioned. So Article 15 clause 4, it is very wider in scope. है ना? कहीं पे भी आप स्पेशल प्रोविजन दे सकते हो. क्या मेंशन किया है क्या स्पेशल प्रोविजन कहाँ पे दे सकते हैं? नहीं मेंशन किया है. So it's a wider in scope. Same is the case with 15 clause 3. Special provision, but in which field it is not mentioned. Okay, right? Article 15 clause 4. Article 15 clause 5, very important. Okay? Article 15 clause 5. Now the difference between Article 15 clause 4 and Article 15 clause 5 is that Article 15 clause 5 explicitly mentions the field in which the special provision can be made. Okay, so I am not writing the Article 15 clause 5 because it's very lengthy. What is Article 15 clause 5? Article 15 clause 5 states that nothing in this article, okay, nothing in this article, now it is very important, nothing in this article or in subclause G of clause 1 of Article 19, meaning nothing in this article or in the Article 19 clause 1 subclause G shall prevent the state from making any special provisions for the advancement of socially and educationally backward classes of citizens and the scheduled caste and scheduled tribes, okay? But where? Insofar as such special provision relate to their admission in educational institutions, admission to educational institutions, including private educational institutions, including private educational institutions, including private educational institutions, whether aided or unaided. Very important, whether aided or unaided. Whether aided or unaided, other than, now this is very important, other than minority educational institutions, other than minority educational institutions. Referred to in clause 1 of article 30, that is in article 30 clause 1. So every fundamental right is interrelated. ठीक है, कितने सारे इस आर्टिकल में कितने सारे आर्टिकल्स के बारे में मेंशन किया है, ठीक है, right. So what is article 15 clause 5? Nothing in this article shall prevent the state from making special provision for the advancement of socially and educationally backward classes of the citizens, and for advancement of scheduled castes and scheduled tribes, where in admission to educational institutions, including private educational institutions, whether funded by the state, whether aided by the state or unaided, excluding minority educational institutions. Now this is the basis of reservation given to SCs, STs and OBCs in higher education institutions. Okay, this is the basis. Okay. Now what is the background? Article 15 clause 4 was added to nullify the Supreme Court's judgment in the state of Madras versus Champakam Dorairajan case. Okay, keep your phone switch off please, in switch off mode. All of you, ठीक है, बंद है फोन आपके, हाँ फाइन, ठीक है. तो इन it was article 15 clause 4, it was inserted to nullify the Supreme Court judgment in state of Madras versus Champakam Dorairajan case. Same was the case in when it comes to article 15 clause 5. Article 15 clause 5 was inserted through 93rd Constitutional Amendment Act, landmark amendment 2005. There was a lot of protest as well. Okay? 93rd Constitutional Amendment Act 2005 inserted Article 15 clause 5. Now this amendment was passed to nullify Supreme Court's judgment in two cases. First was TMA Pi. You will not get all these details in Lakshmikant. That is the difference between teacher and a book. TMA Pi Foundation. TMA Pi Foundation and others versus State of Karnataka and others 2002. Second, PA Inamdar case. PA Inamdar and others versus State of Maharashtra and others, you can 2005. You can simply write PA Inamdar case as well. Okay, I am a teacher, I follow certain rules. Okay. Now TMA Pi Foundation case of 2002 and PA Inamdar case of 2005. Okay, Supreme Court in both the cases, it stated that there cannot be reservation mandated in private unaided educational institutions. Private unaided educational institutions cannot be forced to provide reservation to scheduled caste, scheduled tribes or OBCs. No. Now what was the argument on which Supreme Court said that? Supreme Court said that forcing private educational institutions unaided, which are not funded, okay? Forcing private educational institutions or making them mandatory to provide reservation or to reserve certain seats is a violation of their fundamental right to carry on their occupation. which is provided under Article 19 clause 1 subclause G. Article 19 subclause 1 Article 19 clause 1 subclause G talks about right to freedom of citizens to practice any profession or to carry on any occupation, trade or business. So Supreme Court said that establishing educational institution is an occupation, and if state mandates reservation in this occupation, it is violation of fundamental right under Article 19 clause 1 subclause G. समझे? ये सुप्रीम कोर्ट ने बोला कि आप प्राइवेट एजुकेशन, गवर्नमेंट कैन नॉट इंटरवीन, government cannot mandate its policies to the private educational institutions. Why? Because they have freedom, the individuals, Indian citizens, they have freedom to carry on their occupation. Opening educational institutions, running educational institutions, establish and administer educational institution is a fundamental right of all the citizens under Article 19 clause 1 subclause G. Okay? Right? And this case was also related with the Article 30 of the Indian Constitution. What is Article 30? The Article 15 clause 5 mentions about Article 13. Hey, Article 30 is about right of minorities, whether based on whether based on language or religion, to establish and administer educational institutions of their choice. Okay? So all the minorities, they have fundamental right to establish and administer educational institutions of their choice. Supreme Court in these cases, it said that non-minorities also have right to establish and administer educational institutions of their choice under Article 19 clause 1 subclause G. Minority का अधिकार है, हाँ, एजुकेशनल इंस्टीट्यूशंस को एडमिनिस्टर करना, एस्टैब्लिश करना, कौन से आर्टिकल के अंदर? आर्टिकल 30 के अंदर. सो सुप्रीम कोर्ट ने बोला नॉन माइनॉरिटीज को भी ये फंडामेंटल राइट है. कौन से आर्टिकल के अंदर? आर्टिकल 19 क्लॉज 1 सब क्लॉज जी. नाउ दिस वाज आल्सो अ सेटबैक, राइट? यू नो, इंडिया इज अ वेलफेयर स्टेट. ठीक है, तो प्राइवेट सेक्टर तो कुछ भी करेगा फिर, है ना? राइट? तो इसको नलिफाई करने के लिए, टू नलिफाई सुप्रीम कोर्ट जजमेंट्स इन दिस TMA Pi Foundation and others and PA Namdar case, the government, the 93rd Constitutional Amendment Act was passed in 2005, and it has, if you read closely the Article 19, Article 15 Clause 5, it explicitly mentions private educational institutions, whether aided or unaided. Meaning nothing in the Article 15 Clause 15 or in Article 19 in Article 19 Clause 1 subclause G can prevent the state from making special provision to socially for advancement of socially and educationally backward classes of citizens, or for the scheduled castes and scheduled tribes, insofar as such special provision relate to their admission in educational institutions, whether aided or unaided. Educational institutions including private educational institutions, whether aided or unaided. Okay? So meaning government can mandate reservation. Government can make it compulsory for private educational institutions to implement reservation policy. Can. Okay, right? But can reservation policy be enforced in minority education institutions? No. Why? Because it says that except the minority education institutions. So special provisions or reservation cannot be mandated to minority education institutions. तो आपने देखा होगा माइनॉरिटी एजुकेशनल इंस्टीट्यूशंस में कुछ सीट्स जो है 50% सीट्स जो है वो पर्टिकुलर रिलीजन के जो लोग हैं उनके लिए रिजर्व होते हैं. अगर क्रिश्चियन एजुकेशन इंस्टीट्यूशन है उसमें 50% सेंट स्टीफन्स इज अ माइनॉरिटी एजुकेशन इंस्टीट्यूशन, राइट? ठीक है. अच्छा, अलीगढ़ मुस्लिम यूनिवर्सिटी इज नॉट अ माइनॉरिटी इंस्टीट्यूशन. ठीक है. व्हाट इज माइनॉरिटी इंस्टीट्यूशन? ठीक है, ठीक है, राइट? समझ में आया? आप रिजर्वेशन माइनॉरिटी एजुकेशन इंस्टीट्यूशन में नहीं फोर्स कर सकते हैं. व्हाई? बिकॉज उनको अपनी एजुकेशन इंस्टीट्यूशन एस्टैब्लिश करने का और एडमिनिस्टर करने का फंडामेंटल राइट है, वो वायलेट नहीं कर सकते. ठीक है. नाउ अलीगढ़ मुस्लिम यूनिवर्सिटी इज नॉट अ माइनॉरिटी यूनिवर्सिटी. व्हाई? व्हाट इज माइनॉरिटी एजुकेशन इंस्टीट्यूशंस? ठीक है, डेफिनेशन क्या है ये समझना जरूरी है. माइनॉरिटी एजुकेशन इंस्टीट्यूशन इज अ इंस्टीट्यूशन विच इज एस्टैब्लिश which is established which is established under the act of the parliament, okay, or by the order of the central government, or specified as minority education institution by whom? By National Commission for minorities. ठीक है, नेशनल कमीशन फॉर आई मीन इट इज रिलेटेड टू एजुकेशनल राइट ऑफ माइनॉरिटीज. ठीक है, नेशनल कमीशन ऑन एजुकेशन फॉर माइनॉरिटीज. ठीक है, उसने अगर स्पेसिफाई किया तो वो माइनॉरिटी होगी. ठीक है, तो ये अलीगढ़ मुस्लिम यूनिवर्सिटी कहा गया कि भाई अलीगढ़ मुस्लिम यूनिवर्सिटी वाज नॉट एस्टैब्लिश्ड बाय मुस्लिम. द अलीगढ़ मुस्लिम यूनिवर्सिटी वाज एस्टैब्लिश्ड बाय ऑल द फिलैंथ्रोपिक पीपल. बहुत सारे लोगों ने मिलकर अलीगढ़ मुस्लिम यूनिवर्सिटी इस्टेब्लिश किया था. अलीगढ़ मुस्लिम यूनिवर्सिटी प्रीवियसली वाज द ओरिजिन लाइड इन एंग्लो ओरिएंटल मोहम्मदन एंग्लो ओरिएंटल कॉलेज. ठीक है, सर सैयद अहमद खान ने वो इस्टेब्लिश किया था, बट उन्होंने फंड्स लिए थे, चैरिटी ली थी बाकी लोगों से. सो सुप्रीम कोर्ट ने बोला है कि AMU इज नॉट अ माइनॉरिटी एजुकेशन इंस्टीट्यूशन. ठीक है, सो दैट इज वाई AMU में रिजर्वेशन हो सकता है. समझे? राइट. आर्टिकल 15 क्लॉज 5. नाउ आर्टिकल 15 क्लॉज 5 कहता है कि नथिंग इन दिस स्टेट कैन प्रोहिबिट. अब इसको इंप्लीमेंट करने के लिए कुछ तो होना चाहिए, कुछ तो लॉ पास करना चाहिए. सो टू इंप्लीमेंट आर्टिकल 15 क्लॉज 5, सेंट्रल गवर्नमेंट ऑफ पार्लियामेंट इनैक्टेड सेंट्रल एजुकेशनल इंस्टीट्यूशंस reservation in admission. Reservation in admission Act 2006. ठीक है, सेंट्रल एजुकेशनल इंस्टीट्यूशंस रिजर्वेशन इन एडमिशन एक्ट 2006. क्या था ये? ध्यान से सुनना. दिस एक्ट, सेंट्रल एजुकेशनल इंस्टीट्यूशंस रिजर्वेशन इन एडमिशन एक्ट 2006, provides reservation to scheduled caste, scheduled tribes and OBCs in certain educational institutions established, maintained or aided by the state. Not all central educational institutions, certain educational institutions. Reservation to scheduled caste, scheduled tribes and OBC. Scheduled caste 15%, scheduled tribes 7.5%, OBC 27%. Mind you, before 2006 there was no reservation particularly to OBCs in central educational institutions. And Mandal Commission was about reservation in government jobs. It was not about reservation in education institutions. Mandal part 1 was about reservation to OBCs in government jobs. Mandal 2 was reservation to OBCs in educational institutions, not only private, government education institutions. समझे? Right? Mandal 1 was reservation in government jobs to OBCs. Now, अच्छा, और एक चीज, this act not only provides 27% reservation to OBCs, but it also mandates reservation to scheduled castes and scheduled tribes. There was no law before 2006 which mandated reservation to scheduled castes and scheduled tribes in educational institutions. Okay, so what is the scope of 2006 Act? Reservation to scheduled castes, scheduled tribes and OBCs in certain education institutions maintained, established or aided by the state. Now, Article 15 Clause 5 allows the government to make reservation, to implement the reservation in private educational institutions. But the law passed by the Supreme Court in by the Parliament in 2006 does not mandate the private educational institutions to provide reservation to SC, STs and OBCs. कॉन्स्टिट्यूशन में अगर ये एक्ट के अंदर अगर प्राइवेट एजुकेशन इंस्टीट्यूशन में भी ये रिजर्वेशन इंप्लीमेंट करने का कहा जाता तो वो एक्ट अनकॉन्स्टिट्यूशनल नहीं था. लेकिन गवर्नमेंट ने सोचा कि लेट्स नॉट गो टू फार. ठीक है, तो समझ लो ये बात. प्राइवेट एजुकेशनल इंस्टीट्यूशंस, they are not mandated to provide reservation under 2006 Act. But government can force or can mandate the private sector educational institutions like professional engineering colleges, so on and so forth, to provide reservation. Right? SC, ST, OBC, right? ठीक है, लेकिन क्या अभी उनको मैंडेटरी है? नहीं है। उसके लिए क्या करना पड़ेगा? 2006 एक्ट को अमेंड करना पड़ेगा, ठीक है, बिकॉज 2006 एक्ट डज नॉट इंक्लूड रिजर्वेशन ऑफ STs एंड OBCs पर्टिकुलरली इन प्राइवेट एजुकेशन इंस्टीट्यूशंस, एंड रिजर्वेशन सारे सेंट्रल एजुकेशन इंस्टीट्यूशंस में नहीं होता है. दिस 2006 एक्ट एक्सक्लूड्स सर्टन एजुकेशन इंस्टीट्यूशंस फ्रॉम this reservation, this criteria of reservation. It says that the reservation, certain institutions of excellence, research institutions of national and strategic importance, they are excluded from providing reservation. And whether even if they are central government institutions, they are not mandated to provide this reservation. Let me give you example. ठीक है, space physics laboratory. It is in Thiruvananthapuram. It is a fully funded institution, but this act provides that इस act के अंदर list दिया गया है institutions का कि इन institutions, ये institutions of excellence है, research institutions है, institutions of national and strategic importance ना, ये schedule of the act में mention किए गए हैं और बोला गया कि these institutions are exempted. ठीक है, और एक देता हूँ example. ठीक है, भाभा national institute, होमी भाभा national institute, Mumbai, and various research institutes which are included within, which are part of Homi Bhabha National Institute, ठीक है, like Bhabha Atomic Research Center, Trombay, so on and so forth. वहाँ पे रिजर्वेशन मैंडेटरी नहीं है. ठीक है, समझ में आया? हाँ, गॉट इट. तो सारे एजुकेशन इंस्टीट्यूशंस में रिजर्वेशन नहीं है और प्राइवेट एजुकेशन इंस्टीट्यूशन को मैंडेटरी नहीं है रिजर्वेशन देना. कॉन्स्टिट्यूशन में लिखा हुआ है कि दे सकते हैं, लेकिन प्रैक्टिकली स्पीकिंग आर्टिकल 2006 ने नहीं प्रोवाइड किया है. ठीक है, नाउ द कॉन्स्टिट्यूशनल वैलिडिटी ऑफ 93rd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट एंड दिस 2006 एक्ट, सेंट्रल एजुकेशनल इंस्टीट्यूशंस रिजर्वेशन इन एडमिशन, इट वाज चैलेंज्ड इन द सुप्रीम कोर्ट. अच्छा, ये बताना भूल गया मैं कि ये इसने क्या किया, इस एक्ट ने क्या किया. दिस एक्ट प्रोवाइडेड reservation to scheduled caste, scheduled tribes, and particularly to OBCs in various central education institutions like IITs, IIMs, AIMS, NITs. ठीक है, इसमें रिजर्वेशन मैंडेटरी हो गया. किसके लिए? सिर्फ शेड्यूल्ड कास्ट और शेड्यूल्ड ट्राइब के नहीं, ओबीसी के लिए भी. देखो, मैं आपको एक चीज बता, देयर इज अ डिफरेंस बिटवीन शेड्यूल का रिजर्वेशन टू शेड्यूल कास्ट एंड शेड्यूल ट्राइब्स इन एजुकेशन इंस्टीट्यूशंस एंड रिजर्वेशन टू ओबीसीज इन एजुकेशन इंस्टीट्यूशंस. ठीक है, देखो, शेड्यूल कास्ट और शेड्यूल ट्राइब्स को पहले रिजर्वेशन दिया जाता था. इट वाज नॉट मैंडेटरी, कोई लॉ नहीं था. लॉ तो 2006 में पास किया गया, लेकिन ओबीसीज को कहीं पे भी इट वाज नॉट मैंडेटरी टू प्रोवाइड 27% रिजर्वेशन to OBCs in these institutions, IITs, IIMs, AIMS, NITs, etc. So this 2000 Act made it mandatory for these institutions to provide 27% reservation to OBCs. And there was a lot of protest across the India, and those protests were led by one institution called as Youth for Equality. बहुत सारे लोग मारे गए, प्रोटेस्ट हुआ है ना, देयर वाज लॉट ऑफ एजिटेशन अगेंस्ट व्हाट, अगेंस्ट नॉट प्रोविजन ऑफ रिजर्वेशन टू एससीज एंड एसटीज बट टू ओबीसीज. उन्होंने एक्सेप्ट किया एससी एसटी को, चलो ठीक है, बट व्हाई यू आर प्रोवाइडिंग 27% रिजर्वेशन टू ओबीसीज? गवर्नमेंट ने बोला अफर्मेटिव एक्शन कैनॉट स्टॉप विथ, यू कैनॉट स्टॉप और लिमिट अफर्मेटिव एक्शन टू शेड्यूल कास्ट एंड शेड्यूल ट्राइब्स. We need to we need to extend the affirmative action to the OBCs as well. ठीक है, ठीक है. So this constitutional validity was challenged where? In Supreme Court. The name of the case was Ashok Kumar Thakur versus Union of India 2008. Petitioners ने क्या challenge किया? They challenged the constitutional validity of 93rd Constitutional Amendment Act 2005 and the Central Educational Institutions Reservation in Admission Act 2006. बोले ये unconstitutional, it is violative of right to equality enshrined in preamble of the Indian Constitution and Article 14, 15 जो भी है, right? What did Supreme Court say? Supreme Court upheld Supreme Court upheld the constitutional validity of 93rd Constitutional Amendment Act 2005 as well as 2006 Act in this case, Ashok Kumar Thakur. However, meaning Supreme Court upheld the 27% reservation to OBCs in these education institutions, but Supreme Court excluded creamy layer of OBCs from the benefit of 27% reservation. ठीक है, राइट? ध्यान से सुनना मेरी बात. दो चीजें डिफरेंट है, रिजर्वेशन इन गवर्नमेंट जॉब्स and reservation in education institutions. These are completely different. Reservations in government jobs were given after implementation of the recommendations of Mandal Commission in 1989, and again this was challenged in very famous case, Indira Sahani case, 1992, and in that case Supreme Court upheld the constitutional validity of providing 27% reservation to OBCs in government jobs. So Article 16 talks about reservation in government jobs. Article 15 talks about reservations in educational institutions. This is a difference. समझ में आया? Difference समझ में आया? Right? ठीक है. अच्छा, what about private unaided education institutions? ठीक है. This was a 5-judge bench. ठीक है. It was a 5-judge. No, sorry. अब इसमें क्या हुआ, इसमें भी एक इशू था कि भाई प्राइवेट अनएडेड एजुकेशन इंस्टीट्यूशंस में क्या आप रिजर्वेशन मैंडेटरी कर सकते हैं. ठीक है, राइट? नाउ यस, इट वाज अ 5-judge बेंच. नाउ सुप्रीम कोर्ट in this case did not discuss this issue of providing reservation to OBCs in private unaided education institutions. Why? Because none of the person from private unaided education institutions they were party to this case. उन्हें केस फाइल ही नहीं किया, तो केस अगर फाइल नहीं किया उन्होंने तो वो मैटर देखा ही, वो सुनेंगे ही नहीं वो मैटर. ठीक है ना? द चैलेंज वॉज अगेंस्ट 27% रिजर्वेशन इन IITs, IIMs and all these government education institutions. ठीक है, but one of the 5 judges, Justice Dalveer Bhandari, he said that providing reservation to OBCs in private education institutions, or even for that matter SCs and STs, it is unconstitutional. It is violation of fundamental right under Article 19 Clause 1 Subclause G. But it was not a majority judgment. It was his own individual judgment. But the 5-judge bench in this case did not discuss. It said that we are not discussing this issue. This issue will be discussed on case-by-case basis. We will discuss only the main issue. Got it? तो क्या प्राइवेट एजुकेशन इंस्टीट्यूशंस में क्या अभी मैंडेटरी है उनको रिजर्वेशन देना SC, ST और OBCs का? नहीं. बट इफ दे नीड फंड्स फ्रॉम द गवर्नमेंट, ठीक है, if they need funds from the government, or if they need say recognition from the government, then you can make reservation as one of the criteria. हो सकता है, नहीं हो सकता है, right? तो you can, देखो, state can motivate the private sector to provide reservation, private education institutions to provide reservation, but state cannot make it mandatory. अगर mandatory करना है तो क्या करना है? 2006 का एक्ट अमेंड करना पड़ेगा आपको, क्योंकि 2006 एक्ट limits reservation to SCs, STs and OBCs to the educational institutions maintained, established and aided by the central government and not the other education institutions. And even it is not applicable to all the central government institutions. It is there are certain education institutions which are exempted. समझ में आया? Got it? ये समझ में आया? Article 15 Clause 5, very good. Article 15 Clause 6. Now Article 15 Clause 6, again Article 15 Clause 6 क्या हुआ? Article 15 Clause 6, it was not there in the original constitution. It's a recent addition. Article 15 Clause 6 was added through 103rd Constitutional Amendment Act 2019. What is Article 15 Clause 6? ठीक है, I will not write, just listen to me. Article 15 Clause 6 states that, ध्यान से सुनना, nothing in this article or in subclause G of clause 1 of Article 19 or clause 2 of Article 29 shall prevent the state from making special provision for the advancement of economically weaker sections. nothing in the article 15, nothing in the article 29 clause 2, nothing in the article 19 clause 1 subclause G shall prevent the state from making any special provision for advancement of whom? Advancement of economically weaker sections of the citizens. ठीक है, ये है, ठीक है. अब और क्या कहता है ये आर्टिकल 15 क्लॉज 6? इट ऑल्सो फर्दर स्टेट्स दैट नथिंग इन दिस आर्टिकल दैट shall prevent the state from making any special provision for advancement of economically weaker section of society with regard to their admission in educational institutions, including private educational institutions, whether aided or unaided. And it states that when the reservation is provided, then in case of reservation, अगर special provision reservation का है, तो in case of reservation, the 10% of seats should be reserved to economically weaker sections of society. In where? In central education institutions, including private education institutions, whether aided or unaided. ठीक है? And so this is the so क्या है, अब ध्यान सुनना, ठीक है. आर्टिकल 15 क्लॉज 6 क्या कहता है? 10% रिजर्वेशन देता है इकोनॉमिक वीकर सेक्शंस को. कहाँ पे? वेयर? कहाँ पे? सेंट्रल एजुकेशनल इंस्टीट्यूशंस इंक्लूडिंग प्राइवेट एजुकेशनल इंस्टीट्यूशंस, वेदर एडेड और अनएडेड. ठीक है. 5 क्या है? क्लॉज 15 क्लॉज 5 किसके लिए है? एससीज, एसटीज, ओबीसीज. 15 क्लॉज 6 ईडब्ल्यूएस, 10% रिजर्वेशन. अब आर्टिकल 15 क्लॉज 6 क्या कहता है? जो रिजर्वेशन होगा, दैट रिजर्वेशन विल बी ओवर एंड अबाउ द एग्जिस्टिंग रिजर्वेशन. राइट. सो व्हाट इज द एग्जिस्टिंग रिजर्वेशन बिफोर? इट वाज एससी 15%, एसटी 7.5%, ठीक है. ओबीसीज 27%. टोटल कितना था रिजर्वेशन? 49.5%. So this 10% reservation will be over and above the 49.5%. ठीक है. So currently how many percentage of seats are reserved in various education institutions? कितना? 49.5 plus 10, right? कितना हुआ? 59.5. 50% rule has crossed, and that is why the 103rd Constitutional Amendment Act has been challenged in the Supreme Court. Supreme Court is yet to give its judgment. उन्हें बोला कि ये मंडल जजमेंट का तो वायलेशन है. हाँ, इंदिरा साने केस में क्या बोला है? दैट द टोटल क्वांटम ऑफ रिजर्वेशन शुड नॉट गो बियॉन्ड 50% अनलेस इन सडन एक्सेप्शनल सर्कमस्टेंसेस और एक्स्ट्रा ऑर्डिनरी सिचुएशंस. तो पिटिशनर ने बोला ये एक्सेप्शनल सिचुएशन नहीं है, एक्स्ट्राऑर्डिनरी सिचुएशन नहीं है, 50% क्रॉस करने का कोई इतना जल्दबाजी नहीं था, तो ये चैलेंज किया गया. दे सेड दैट इट्स वायलेशन ऑफ बेसिक स्ट्रक्चर ऑफ द इंडियन कॉन्स्टिट्यूशन. 103rd Constitutional Amendment Act 2019, but Supreme Court has not yet given the judgment, and it has refused to stay on this reservation, 10% reservation to EWS. अब क्या है? गवर्नमेंट ये आर्टिकल 15 क्लॉज 6 में तो लिख दिया, ठीक है, राइट. अब आर्टिकल 15 क्लॉज 6 में क्या है? जो इकोनॉमिकली वीकर सेक्शंस कौन से? जो जनरल कैटेगरी के, जो अपर कास्ट है, उनके इकोनॉमिकली वीकर सेक्शंस, बाकी के नहीं. व्हाई? बिकॉज दे आर ऑलरेडी गेटिंग रिजर्वेशन इन एससी, एसटी और एज ओबीसी. So the 10% reservation to EWS, it is given to the weaker sections within upper caste. Not ये 10% में ये SC, ST, OBCs नहीं आएंगे, है ना. तो ये आर्ग्यूमेंट थी ना कि भाई रिजर्वेशन जो है अपर कास्ट लोगों में भी कुछ ब्राह्मण, फॉर एग्जांपल कुछ ब्राह्मण जो है वो बहुत गरीब है, जस्ट बिकॉज दे आर ब्राह्मण दे आर डिनाइड रिजर्वेशन. ये तो गलत है, इसलिए फिर ये आर्ग्यूमेंट देके ये लाया गया. ठीक है, समझ में आया. अब गवर्नमेंट ने क्या बोला? गवर्नमेंट अब नाउ टू इंप्लीमेंट आर्टिकल 15 क्लॉज 5, गवर्नमेंट इनैक्टेड Central Education Institutions Act 2006. But to implement this, government did not pass any act. Government issued executive order कि भाई एजुकेशन इंस्टीट्यूशंस में जो है 10% रिजर्वेशन होना चाहिए. नाउ दिस ऑर्डर इंक्लूड्स 10% रिजर्वेशन टू ईडब्ल्यूएस इन प्राइवेट एजुकेशन इंस्टीट्यूशंस एज वेल. मतलब 10% रिजर्वेशन जो ईडब्ल्यू वो प्राइवेट एजुकेशन इंस्टीट्यूशन में भी देना चाहिए. ठीक है, राइट. हाँ, एंड गवर्नमेंट ने ये भी बोला है कि वी विल दिस पर्टिकुलर ऑर्डर विल ऑल्सो बी एक्सटेंडिंग टू द मैंडेटिंग द रिजर्वेशन टू ओबीसीज इन SC ST एंड ओबीसीज इन प्राइवेट एजुकेशन इंस्टीट्यूशंस. ठीक है, राइट, गॉट इट, फाइन. सो दिस इज अबाउट आर्टिकल 15 क्लॉज 6. अब क्या SC की लड़की है, गरीब है, वो उसको मिल रहा है ना इसमें 15% में.
15% मिल रहा उसको SC के लिए.
हाँ,
वो लड़की है तो
लड़की के लिए कहा, देयर इज नो रिजर्वेशन ऑन द बेसिस ऑफ जेंडर. वेयर इज रिजर्वेशन ऑन द बेसिस ऑफ जेंडर? स्पेशल प्रोविजन कौन सा? रिजर्वेशन थोड़ी है विमेन को. देयर इज नो रिजर्वेशन टू विमेन इन एजुकेशन इंस्टीट्यूशंस. वो स्पेशल प्रोविजंस मैंने आपको एग्जांपल दिया ना, फी कंसेशन हो सकता है, स्कॉलरशिप दे जा सकते हैं, हॉस्टल कंस्ट्रक्ट किए जा सकते हैं, वो है. देयर इज नो रिजर्वेशन, माइंड यू, देयर इज नो रिजर्वेशन टू वुमेन इन एजुकेशनल इंस्टीट्यूशंस. देयर इज नो रिजर्वेशन टू वुमेन इन गवर्नमेंट जॉब्स. देयर इज रिजर्वेशन टू वुमेन इन पंचायती राज इंस्टीट्यूशंस एंड अर्बन लोकल बॉडीज. अपार्ट फ्रॉम दैट देयर इज नो रिजर्वेशन. समझे? हाँ, डोंट गेट कंफ्यूज. रिजर्वेशन किसको है? SC 15%, क्वांटम ऑफ रिजर्वेशन. ST 7.5%, OBCs कितना? 27%. अच्छा, नाउ रिमेंबर दिस, बहुत इंपॉर्टेंट है. द आर्टिकल 15 क्लॉज 3, क्लॉज 4, क्लॉज 3, क्लॉज 4, क्लॉज 5, क्लॉज 6, they are not mandatory. They are not mandatory, meaning it is not constitutionally binding on the state to make special provision to the scheduled caste, scheduled tribes and OBCs. ठीक है? Article 15 clause 3 to clause 6, they are discretionary in nature. Nothing in this article shall prevent the state. Article 15 does not state that state shall make special provision for advancement of SC, ST and OBCs. So Article 15 clause 3, 4, 5, 6, it does not confer any fundamental right to any citizen. Meaning fundamental right तो है, लेकिन there is no fundamental right to get reservation. Supreme Court ने भी यही बोला है. There is no fundamental right to get reservation. Government can give reservation, ठीक है, but you cannot claim getting reservation as a matter of fundamental right. No, you do not have fundamental right to get reservation. State might provide, state can provide, and state is not prevented from providing reservation, right? So Article 15 clause 3 to 6, it is discretionary in nature. It is not constitutionally binding on the state to provide, to make certain special provisions. State may or state may not provide certain special provisions. समझे? ठीक है, राइट? अब आर्टिकल 15 क्लॉज 6 ने क्या कहा कि हु विल बी इकोनॉमिक वीकर सेक्शंस. सुप्रीम कोर्ट ने बोला कि इकोनॉमिकली वीकर सेक्शंस अंडर आर्टिकल 15, सॉरी सुप्रीम कोर्ट नहीं, सॉरी आर्टिकल 15 क्लॉज 6, ठीक है, वो कहता है कि इकोनॉमिकली वीकर सेक्शन अंडर आर्टिकल 15 क्लॉज 6 एंड अंडर आर्टिकल 16 क्लॉज 6 एज वेल would be notified from time to time by the state on the basis of family income, or any other indicators of economic disadvantage. तो ये गवर्नमेंट के ऊपर छोड़ दिया, स्टेट विल ये किया, ठीक है. अब और एक चीज, is the central government is it binding on the central government to provide reservation? No. So is it binding on the state governments as well? नहीं. जरूरी नहीं कि सेंट्रल गवर्नमेंट ने रिजर्वेशन दिया तो स्टेट गवर्नमेंट ने भी रिजर्वेशन देना है एजुकेशन इंस्टीट्यूशंस में, वो उनके ऊपर है. और सेंट्रल गवर्नमेंट के ऊपर भी बाइंडिंग नहीं है कि रिजर्वेशन देना है. इट इज डिस्क्रिशनरी. समझ में आया? ठीक है. लेकिन यूजुअली क्या है, सेंट्रल गवर्नमेंट ने अगर रिजर्वेशन दिया तो उसको इंप्लीमेंट करते हैं स्टेट गवर्नमेंट भी, फॉलो करते हैं उसको. और दूसरी बात, क्वांटम ऑफ रिजर्वेशन डिफर्स फ्रॉम स्टेट टू स्टेट एज वेल. ये तो मैं सेंट्रल एजुकेशन इंस्टीट्यूशन का बताया है 15, 7.5 एंड 27. बट द क्वांटम ऑफ रिजर्वेशन टू SC, ST एंड OBCs इट डिफर्स फ्रॉम स्टेट टू स्टेट. कुछ स्टेट में ये क्वांटम अलग है, कुछ स्टेट में SC, STs है ही नहीं, तो रिजर्वेशन कहां से देना है? नहीं देना रिजर्वेशन. कुछ स्टेट में मेजोरिटी ऑफ STs है तो SC को 15% नहीं देना है. क्वांटम ऑफ रिजर्वेशन डिफर्स फ्रॉम स्टेट टू स्टेट बेसिस. स्टेट गवर्नमेंट जॉब्स में क्वांटम ऑफ रिजर्वेशन डिफर्स. इट माइट डिफर, ये इतना भी हो सकता है या डिफरेंट भी हो सकता है. डिफर्स फ्रॉम स्टेट टू स्टेट. समझे? डोंट गेट कंफ्यूज्ड. And is it mandatory for the state governments to provide reservation if the central government provides reservation? नहीं, ना सेंट्रल गवर्नमेंट के ऊपर मैंडेटरी है, ना स्टेट गवर्नमेंट के ऊपर मैंडेटरी है स्पेशल प्रोविजन बनाना किसके लिए? SC STs OBCs के लिए, ठीक है. बट इट कैन एंड आइडियली इट शुड बिकॉज इंडिया इज स्टिल अ वेरी पुअर कंट्री. राइट नाउ आर्टिकल 50 अब क्या बोला? अब व्हेन इट कम्स टू 27% रिजर्वेशन टू OBCs, सुप्रीम कोर्ट ने क्या बोला इन अशोक कुमार ठाकुर? It said that the creamy layer of OBCs should be excluded from the benefits of reservation. ठीक है. अब creamy layer कैसे आइडेंटिफाई किया जाता है? On the basis of creamy layer within OBC is identified on the basis of gross annual family income. Gross annual final income. ठीक है. This is the income criteria for OBCs. It is currently 8 lakh rupees. For OBCs. Now, interestingly speaking, this annual gross annual family income, not only individual, family income of criteria of 8 lakh to OBCs does not include income from salary. समझे? जो ये 8 लाख जो एनुअल ग्रॉस फैमिली इनकम जो काउंट किया जाएगा उसमें सैलरी इज नॉट इंक्लूडेड. And that is why there was a proposal in the government to increase the creamy layer limit from 8 lakh to 12 lakh and to include salary as part of annual gross family income. But because of the elections in 5 states, government has put on hold this proposal. दो proposal है. एक तो obviously support करेंगे कि भाई 8 लाख से बढ़ा दो 12 लाख रुपीस क्योंकि अभी इन्फ्लेशन एंड ऑल, राइट. और दूसरा क्या है? टू इंक्लूड सैलरी एज अ पार्ट ऑफ ग्रॉस एनुअल फैमिली इनकम. तो अभी जो 8 लाख का जो क्राइटेरिया होता है उसमें सैलरी को कंपोनेंट नहीं ऐड किया जाता है. तो अगर आपका 12 लाख पैकेज है आपका, ठीक है, हाँ, एज अ सैलरी, वो 12 लाख आपके ये इसमें ग्रॉस एनुअल फैमिली इनकम में नहीं काउंट किया जाएगा. बाकी योर इनकम फ्रॉम अदर सोर्सेस. तो बहुत सारे लोग क्या है पता है? अब मैं सपोज प्रोफेसर हूँ. आई एम प्रोफेसर इन दिल्ली यूनिवर्सिटी, असिस्टेंट प्रोफेसर इन दिल्ली यूनिवर्सिटी, ठीक है, राइट. एंड सपोज आई एम इन OBC, सो माई सैलरी विल नॉट बी कैलकुलेटेड इन ग्रॉस एनुअल इनकम, ठीक है. सो व्हाट विल बी माई इनकम? माई फादर इज फार्मर. सो व्हाट आई विल शो? आई विल शो दैट सी my father is farmer and the income from agriculture is less than 8 lakh rupees. So that is why even if I am a professor, ठीक है, I will get the OBC reservation for any other job if I decide to apply the other job. समझे? इसीलिए, right? But this OBCs, the senior civil servants and children of politicians like MPs and MLAs and etc., they are not included in benefits of I mean they are considered as creamy layer. They will not get the benefit of OBC reservation. Senior civil servants और ME MP MLA जो भी है उनके बच्चे. अब catch. Now who decides EWS, economically weaker section of society? The government, ठीक है. Central, when it comes to central education institution, central government ने क्या बोला? ठीक है, central government ने भी यही बोला कि भाई EWS में कौन आएगा? Following criteria, those who fulfill following criteria. पहला criteria क्या है? Annual gross annual family income. कितना है EWS के लिए? 8 लाख. OBCs के लिए 8 लाख है, यहां पे भी 8 लाख है. But here for 10% EWS, here the income from salary is added. It is a part when it comes to economic weaker sections of society. So income from all the sources, salary, business, profession, agriculture, it is included when it comes to calculating annual gross income of 8 lakh for whom? EWS. But the salary is not a part of component of OBC creamy layer. ठीक है. और बाकी क्राइटेरिया क्या है? The government order states that the person whose family possess following would be excluded from the benefits of 10% reservation. Number one, ये तो ये पहला criteria है, ठीक है. Then who owns agricultural land of 5 acre and above, है ना. Then who possesses the flat, है ना, flat of 1000 square feet or above and above, ये हो गया. दूसरा है who possesses plot of 100 square yard or above in notified municipalities, ठीक है. और who possesses 200 square yards of plot in areas other than notified municipalities. अगर म्यूनिसिपैलिटीज है तो 100 स्क्वायर यार्ड का प्लॉट अगर है तो आप ईडब्ल्यूएस में नहीं आएंगे. और अगर नॉन नोटिफाइड म्यूनिसिपल मतलब गांव है, रूरल एरियाज है, उसमें 200 यार्ड्स से ज़्यादा अगर है तो आप ईडब्ल्यूएस में नहीं आएंगे. सो दिस इज द क्राइटेरिया, समझे. सो नॉट ऑल द अपर कास्ट दे हैव 10% रिजर्वेशन, उसमें भी. सो रिमेंबर क्रीमी लेयर अप्लाइज टू ओबीसी रिजर्वेशन, क्रीमी लेयर अप्लाइज टू ईडब्ल्यूएस एज वेल, बट देर इज नो क्रीमी लेयर व्हेन इट कम्स टू शेड्यूल कास्ट एंड शेड्यूल ट्राइब्स, ठीक है, राइट. अच्छा, और एक चीज, क्या कहीं पे यहाँ पे लिखा हुआ है कि ये रिजर्वेशन टू ओबीसीज, एससीज एंड एसटीज इन एजुकेशन इंस्टीट्यूशंस विल कंटिन्यू ओनली टिल 10 years और इट शुड कंटिन्यू टिल 10 years, इट शुड बी, ऐसा कहीं लिखा हुआ है क्या? नो. कहा कौन सा कमीशन ने बोला? यही तो मैं, मोस्ट ऑफ द पीपल हैव लैक ऑफ अंडरस्टैंडिंग ऑन रिजर्वेशन. पता ही नहीं है लोगों को. लोग कहते ना कि ये रिजर्वेशन जो है 10 साल के लिए ही दिया गया था कॉन्स्टिट्यूशन में, हाँ हाँ 10 साल तक ही दिया. अरे भाई साहब, वो 10 साल का जो लिमिट था दैट वाज रिलेटेड टू रिजर्वेशन टू शेड्यूल कास्ट एंड शेड्यूल ट्राइब्स इन पार्लियामेंट, इन लोकसभा, नॉट दैट टू लोकसभा, नॉट इन राज्यसभा. देयर इज नो रिजर्वेशन इन राज्यसभा. समझे कि नहीं? जो 10 साल का लोगों को पता ही नहीं है. नीदर आर्टिकल 15 नॉर आर्टिकल 16 प्रिस्क्राइब एनी टाइम लिमिट about for how many years the reservation will be exist. That time limit of 10 years is for reservation to SCs and STs in Lok Sabha and state legislative assemblies, not in education institutions, not in government jobs. Clarity आ गया. तो इसलिए ये वो व्हाट्सएप यूनिवर्सिटी में जो आपको मैसेजेस आते हैं ना, डोंट फॉलो देम, अप्लाई योर लॉजिक, ठीक है, राइट. एंड यस, सुप्रीम कोर्ट in Ashok Kumar Thakur, while upholding the 93rd constitutional validity of 93rd Constitutional Amendment Act, it also said that you know it upheld the 27% reservation given to OBCs. It said that this particular reservation scheme should be reviewed after every 10 years. 10 साल में जो है ये रिव्यू करना है. ये सुप्रीम कोर्ट ने बोला है, कॉन्स्टिट्यूशन में कहीं नहीं लिखा हुआ है ये. गॉट इट? ठीक है. सो आई होप यू हैव क्लियरली अंडरस्टूड द आर्ट. सो सिर्फ एक आर्टिकल हमने 1.5 घंटे में डिस्कस किया. वाई? बिकॉज इट्स वेरी इंपॉर्टेंट. देयर वॉज नॉट अ सिंगल वर्ड इन दिस क्लास विच वॉज नॉट इंपॉर्टेंट. And there are so many things which you understood. Okay? So to summarize, Article 15 is available only against this. It is available only to the citizens. It is not available against. It is not available to the foreigners. Okay? Right? And certain Article 15 Clause 1 is available only against the state. Article 15 Clause 2, it is available both against the state and individuals. Okay? And then Article 15 Clause 1 and 15 Clause 2 speaks the language of equality before law, whereas Article 15 Clause 3 to 6 they speak the language of equal protection of laws, treating equals equally but unequals unequally. That is the foundation of affirmative action. Reservation is one of the affirmative actions. Okay, right? And I told you that the provisions under Article 15 Clause 3 to 6 they are discretionary in nature. Okay? They are it is not constitutionally binding on the state to make special provision to socially and educationally backward classes of the citizens, including women and children. Okay? State may or state may not provide, and state do provide. And और एक चीज क्या, there is no fundamental right to reservation in Indian Constitution. Is there any article which talks about right to reservation? Article 15 clause, Article 15 does anywhere he says that you have SC, ST and OBCs, they have fundamental right to reservation. Is there anything? Whether to provide reservation or not, it is absolutely discretionary on the part of सेंट्रल गवर्नमेंट एज वेल एज द रिस्पेक्टिव स्टेट गवर्नमेंट्स. ठीक है. अच्छा, इज इट मैंडेटरी फॉर द स्टेट गवर्नमेंट्स टू प्रोवाइड रिजर्वेशन टू 10% रिजर्वेशन टू ईडब्ल्यूएस? नो. ठीक है. तो वो स्टेट गवर्नमेंट डिसाइड करेगा कि 10% ईडब्ल्यूएस को रिजर्वेशन देना ही नहीं देना है. हाँ, जो अपने उनके जो एजुकेशन इंस्टीट्यूशन है उसमें. हाँ, राइट. स्टेट गवर्नमेंट डिसाइड करेगा कि हमारे जो एजुकेशन इंस्टीट्यूशन है फंडेड बाय स्टेट गवर्नमेंट, उसमें 27% रिजर्वेशन देना ही नहीं देना है. समझे? Right. And what is the but it is the whatever things which are mentioned in article 15, article 15 uses the word the state. What is the word state? We have discussed article 12 definition of state. The state includes parliament of India and government of India. Second, legislature of the state and government of the state. Right. So the provisions under article 15 applies to both central government and state government as well. But when it comes to education institutions, it also when it comes to education institutions, it applies to both central educational institutions as well as state educational institutions. Okay? But 2006 Act is act passed by the Parliament. It is not a central government act. And education is a concurrent subject. Both state and central government and state government can pass laws when it comes to the state, when it comes to the education, because it's a concurrent subject under the 7th schedule. Got it clear? बहुत बढ़िया. Any questions you have? क्लैरिटी है? ठीक है, फाइन, थैंक यू. टुमारो वी विल डिस्कस आर्टिकल 16. ठीक है, टुमारो और व्हेनेवर द क्लास इज शेड्यूल्ड. थैंक यू.